Unit 6 is probably this unit that most students enjoy the most because they enjoy talking about criminal law and civil law and Miranda rights and the police. However, some students fear and dread this unit because you have to know about court cases. And we're going to review those court cases with you, hopefully give you some strategies and hints to remember them. But you do need to know these court cases as well as differences between civil law and criminal law. And we'll talk more about that as we get going. There are three main types of law, American law, you need to be familiar with for the government HSA. And the first one is simple, criminal law. And if you look at the word criminal law, you see the word crime or criminal, and you probably know what that refers to. Somebody that breaks a law, commits a crime. And you have different types of laws. You have serious criminal laws like murder, rape, arson, but then you have vandalism, shoplifting, stealing candy from an old lady. Those are all examples of criminal law. The second type of dispute that we come across is civil law. And the way I like to tell my students the difference between criminal and civil law is that civil law deals with shows like Judge Judy or Judge Joe Brown. My favorite, the old People's Court, where you have two people or sometimes more than two people and they have a dispute. They have some type of conflict between people. Sometimes the government's involved, but not always. And so examples of this, for instance, would be contracts, adoption, divorce, torts. Let's say you're walking down the supermarket and you slip on a banana and you break your head or something like that. You want to sue the supermarket for, putting that banana on the floor. That's civil law. Constitutional law deals with what I like to call big-time issues, something that's in the Constitution or sometimes something that's related to the Constitution, whether it's free speech rights or marriage rights or equality, big-time issues that require interpretation of the Constitution. Something you have to be familiar with when it comes to the courts is the concept of jurisdiction. Jurisdiction refers to who has power. It's very similar to the concept of federalism. Who are you going to complain to? Well, if you have a conflict, you need to know which court are you going to go to. And so that's where jurisdiction comes in. There are two types of jurisdiction that you need to be familiar with for the HSA. The first type of jurisdiction is called original jurisdiction. And if you look at the word original, original means the first. You're the first. And so this is where you go for the first trial. This is important because it's in original jurisdiction courts that you actually have a trial, that evidence is presented, that witnesses go to the stand. This is the type of court that you often see on shows like Law and Order, CSI, I guess things like that. Let's say you're not satisfied with your decision in the original court and you feel that you deserve a new hearing. Well, you would then appeal your decision and go to an appellate court. And so an appellate court deals with appellate jurisdiction. And if you look at the word appellate, it's very similar to the word appeal. And this is where you want a higher up court to review and look over whether or not a lower court made a mistake. There is no new evidence presented here. You can't bring new witnesses or new evidence. The appellate court only looks at the previous trial and decides if there was wrongdoing or if the judge or jury didn't do something they were supposed to. Here's an example that hopefully will clear up the word appellate if you are still confused on what appellate means. So I love this example. So let's say you have a teacher and they tell you at the beginning of the year, the only way you get an A is if you get a 90% or better in the class. Well, one marking period, you earn an 89.3% on your report card, which technically is a B. And your stubborn, hard-nosed teacher says, nope, I am not going to give you an A. You earned a B. Who would you appeal to change your grade to an A? And so obviously you're originally going to try to persuade and lobby the teacher to change your grade. But let's say the teacher doesn't want to change the grade. Who might you try to lobby? Who might you try to appeal to? Possibly a guidance counselor, possibly a vice principal, possibly, or maybe even all the way up to the principal, and maybe even up to the superintendent, if you really wanted to go that far. But the key is that you have to start at the bottom, and then you have to work your way up to the top. You just can't jump from the teacher all the way to the superintendent to appeal. You have to go through the steps, you have to go through the process. In this slide, you see a visual representation of how our federal court system is laid out. And this is only at the national level. So each state has a layout very similar to this. They have different names, but at the federal level, you have at the top the Supreme Court, and there's only one Supreme Court. The Supreme Court here is both original and appellate jurisdiction, which means sometimes you go to the Supreme Court first. There are very specific reasons why you can go to the Supreme Court first. It doesn't happen very often. The Supreme Court mostly hears appellate cases, people that aren't satisfied with lower rulings and they want the Supreme Court to step in. Below the Supreme Court, you have the U.S. Court of Appeals, and there's 12 of these circuits. These are solely and wholly appellate courts, and there's 12 of them, and they're geographically spread all over the country. And then below the courts of appeals, you have the U.S. district courts. And the district courts, there's much more of these. These are geographically spread out as well. Here is where the original federal trial takes place. Most crimes that people commit are usually state or local crimes. However, if you do commit a federal crime, then you would go to the district court first. Due process is probably the most important item you can learn and use for the rest of your life that you get from an LSN government class. Due process refers to those guarantees and liberties in the Constitution that cannot be taken away from you if you are accused of a crime. The word or the phrase due process comes directly from the Fifth Amendment and the 14th Amendment. And the Fifth Amendment applied due process to the national government. The Fifth Amendment says the national government cannot deprive you of life, liberty without due process of law. The 14th Amendment, which came about after the Civil War, forced states and local governments to also provide you due process. And through the interpretation of the 5th and 14th Amendment in different Supreme Court cases, we have created in this country a bunch of due process rights that protect us. I bet you know a bunch of these. Ever heard of Miranda rights? If you're accused of a crime, you can't afford a lawyer. Who has to give you a lawyer? The government has to give you a lawyer. Do you have to speak to a police officer, or do you have to speak if you're a witness on trial? Nope. You can plead the Fifth. You don't have to incriminate yourself. You don't have to make yourself look guilty. Can the government just keep you in jail forever without telling you why? No way. The government has to give you a quick and speedy trial. These are just some of the due process rights that all of us are afforded. It doesn't matter if you're a citizen, it doesn't matter if you're an immigrant, it doesn't matter if you're here just visiting on vacation. Everybody gets due process rights. We're going to go into some more detail now about your due process rights. The HSA loves testing students on due process rights because these are the most important liberties that the government cannot take away from us. The first set we're going to look at are the ones that come under the Fourth Amendment, primarily the idea that the government cannot illegally search you or illegally seize or take anything away. An example of that would be a wiretap. So let's say you're accused of a crime. The government can actually listen to your phone conversation if they get a warrant from a judge saying that that is an acceptable thing to do. Another example is when the government comes to your house and let's say they need to take something from you. Let's say you've been arrested and they want to search your house for the knife. They need a warrant. They need a document saying the government has a right to do such a thing. Also, the police need a warrant to arrest you if they didn't observe you commit a crime. The biggest part of due process comes from the Fifth Amendment because there's so many liberties included in the Fifth Amendment. For instance, you have a right against self-incrimination. What that means, you don't have to testify against yourself in court. Or, as many people like to say, they can plead the Fifth and refuse to answer a question and remain silent. The second part of the Fifth Amendment refers to double jeopardy. And if you look at the word double, you know that means two. So what that means is you cannot be charged more than once for the same crime. So O.J. Simpson, he was found not guilty of killing his ex-wife. He could never be put on trial for that crime again. Eminent domain is a fancy phrase that refers to the idea that the government must repay you if they take your property. A great example of this is, let's say the government's building this brand new highway. They need to tear down your house to build this highway. The government can tear down your house, but they must pay you fairly for the price of your house. The Sixth Amendment guarantees that all people get a speedy, a fast, and public and open trial. So your trial can't be hidden away and put in some dungeon. It has to be open to the public. And another part of the Sixth Amendment, as well as the Gideon case, is that you must receive a lawyer. The last part of due process we'll study is the Eighth Amendment that says no excessive bail or punishment can be put on a suspect. So if you're accused of a crime, the government can punish you. However, the punishment must meet the crime. You can't be put to death for stealing candy from a convenience store. However, you could be put to death if you, God forbid, killed a police officer. That's a serious crime, and with a serious crime, you can get serious and very, very life-threatening punishments. In the next few slides, we're going to be looking over the differences between criminal law and civil law. And we've already talked about this a little bit, but we're going to go into some more details in terms of who's involved and the processes. In criminal law, you deal with people committing a crime or breaking the law. And you have three main groups of people involved. You have someone called the prosecution or the DA, the district attorney. These are the people that represent the government. They are the ones trying to prove that you are guilty. You, if you are accused of a crime, are the defendant. And you will have, hopefully, some counsel if you want it, if you buy it, or if you ask for it from the government. And the defendant is trying to prove their innocence. In a criminal law, you also have something called a petit jury. And the petit jury are the 12 people, sometimes it's less, who decide who is innocent, who is guilty, who should win, who should lose. So let's go through these steps very quickly here. The first thing that happens is you're arrested. The police catch you doing something illegal, or they come to your house with a warrant and they take you into custody for possibly committing a crime. The next step is called the grand jury. And the grand jury, this is something that's in the Constitution, In order for the whole process to continue, a grand jury must decide if you should be indicted. This word here means, or it's pronounced indict. What that means is the grand jury looks at all the evidence. They're not deciding if you're innocent or guilty. The grand jury is only deciding, is there enough evidence to keep this process going? And if a grand jury thinks there's enough evidence, the case keeps going. If the grand jury decides, man, the government has a weak argument, not enough evidence, the process stops and you go home free. I put a star next to number 3 because this doesn't always happen, but it does happen 90% of the time. Oftentimes, we get something called a plea bargain. And if you look at the two words, plea and a bargain, I think of this as you go to a store and you're trying to get the best bargain. You're trying to get the best deal. And the word plea is when you state something. So if you put that together, it's when you state something in order to make a deal. Well, what happens in a plea bargain, they're very controversial, is that the defendant pleads guilty to a lesser crime, but they get a lighter punishment. And so let's say the prosecution pretty much can prove that you're guilty, but they don't have enough overwhelming evidence to get the most severe punishment. A plea bargain will please the government because you're going to serve some time, you're going to be punished, while the defendant might get a lesser punishment because the government doesn't have the best and the most evidence. If you don't take a plea bargain, then you go through the whole trial process where you present evidence, witnesses, and then after that takes place in step 5, the petit jury reaches their decision, innocent or guilty, and then you have the judge. The judge is a neutral, impartial, unbiased person that states the punishment for the defendant if the defendant is found guilty. Next, we're going to look at the intricacies of civil law. And as we mentioned before, civil law doesn't deal with crime. You're dealing with some type of dispute or conflict or argument. You have a plaintiff, and the plaintiff is the person that is making the complaint. And if you look at the word plaintiff, you can see part of the word plaint or complaint. This is the person that wants damages, they want money. They're the person that might be the victim of this conflict. The defendant is the person accused of causing damages. And then sometimes you have a jury, sometimes you don't. It depends upon the state and the local jurisdiction. Let me give you an example. Let's say you have Juana, and Juana is walking to school, and she is on the school sidewalk. Juana is walking at a steady, normal pace. Juana slips, breaks her elbow, and is mad as heck. Well, Juana might sue the school. She might file what you call a lawsuit. And because Juana is the person bringing the complaint, Juana would be called the plaintiff. And who is she accusing of causing this wrongdoing, causing her to slip? She is suing the school. And so the school would be the defendant. Juana would be the plaintiff bringing the complaint. The first thing Juana would do, Juana would want to hire a lawyer to get legal advice. The lawyer files a written formal complaint. This is the document with the charges against the school, the defendant. And number 3, you have pretrial discovery. So each side is looking for evidence, talking to witnesses, getting statements to prove their story, their side of the story. In step 4, just like in criminal law, most cases end here where you have a resolution without a trial. Maybe the school settles with Wanda, they give her some money just to keep her quiet, or a mediator or arbitrator, somebody who's neutral, a third person, looks at the case and decides, Wanda really is right here, or Wanda has no case here. Oftentimes, civil cases end at step 4. However, if you get to step 5, the trial takes place. Each side provides evidence, provides witnesses, provides testimony, and Either a jury or a judge decides who has the preponderance of evidence. We'll talk about that in a second. And if the plaintiff wins, if the plaintiff has the preponderance of evidence, then the plaintiff gets the damages, which is money. Money to pay for the medical bills, or sometimes punitive damages, money for suffering, which can depend on what the plaintiff is asking for and what the judge and jury think is allowable. Burden of proof deals with who has the duty of proving a disputed charge. So in criminal law and civil laws, there's different levels of burden of proof. And in criminal law, you have something called beyond a reasonable doubt. This is the name of the burden of proof used. This is the hardest and highest burden of proof there is. In order for a judge or jury to decide if somebody is guilty, the jury cannot have any doubt to find this defendant guilty. It is very hard to prove this, and it makes sense. If the jury finds somebody guilty, the defendant goes to jail, pays a fine, could possibly be killed through the death penalty. Finding somebody guilty in criminal law translates into taking away that person's liberties for maybe a few years, maybe the rest of their life. And so the jury must be nearly 100% sure in order to find the defendant guilty. That's why the burden is called, you have to be beyond a reasonable doubt. You can't have any doubt. In the case of O.J. Simpson, back in the early 90s, he was found not guilty because his lawyers were able to put enough doubt in the jury's mind, enough doubt to make the jury say, well, you know what, I'm not 100% sure. He could be innocent. Preponderance of evidence is the burden of proof used in civil law. This is much, much easier to prove. In preponderance of evidence, the civil jury or the judge is deciding who has more powerful, more convincing evidence. You don't have to be 90% sure in civil law to decide who is right, who is wrong. In civil law, because you have a plaintiff, because you have a defendant, and because there's no possibility of jail time, the burden is much, much less. And it's a lot easier to prove. In this case, O.J. Simpson, back in the early 90s, he had to pay money to the plaintiffs in the case that sued him for wrongful death, for being civilly responsible for the death of his ex-wife and the ex-wife's friend. The burden of proof in civil law is much, much lower. It's much easier to find somebody liable. You notice how the word guilty isn't used, the word liable is used. Somebody who is liable is somebody who is responsible for a wrongful act to occur. So if you can, keep in your mind logically here, you don't have to memorize this, but it makes sense logically. In criminal law, the government can take away your life, can take away your liberty, and so the burden is much higher. In civil law, because the only thing you can lose is money, which really doesn't matter when it comes down to it, the burden of proof is much, much less. And here we come to the part that students dread the most, memorizing these 8 important Supreme Court cases. Now, some of you might be like, 8? Oh my God, this is really hard. Well, if you take AP Government, you sometimes have to memorize more than 40 court cases. And if you someday want to become a lawyer and you want to go to law school, well, you have to memorize possibly hundreds of court cases. You have to know them. So 8, when you think about it, really isn't that big of a deal compared to law school. Now, some of you are still shaking your heads, being like, you're crazy. But let's stick to these 8. In Marbury v. Madison, this is considered the most important court case that the Supreme Court has ever come across, because in Marbury v. Madison, the court created something called judicial review. And we've talked about this before. But judicial refers to the courts, the judicial branch, to have the ability to review, to look over and decide if a government action is constitutional or not constitutional. Every other case since Marbury versus Madison would not have been able to take place if it wasn't for the precedent of this case of creating judicial review. In McCullough versus Maryland, the Supreme Court explained the purpose of the elastic clause, or the necessary and proper clause, meaning that the national government can do things not necessarily or specifically written in the Constitution. The Constitution's only a few thousand words, doesn't get very technical, doesn't get very specific, and the court in McCullough versus Maryland said the national government can do things that are necessary and proper in carrying out its enumerated, its specifically listed powers. Another part of McCullough versus Maryland is that, let's say there's a conflict between the states and the national government. The national government is supreme. They would win the fight. Plessy versus Ferguson and Brown versus Board of Education are related. They both deal with the issue of segregation. Segregation is the splitting up of people, usually based on race. In Plessy versus Ferguson in 1896, the Supreme Court said the states could segregate people by race if people were segregated using the principle separate but equal. So as long as you had black facilities and white facilities that were somewhat equal, then segregation could be used. Well, about 58 years later, you get Brown versus Board of Education in 1954, and the Supreme Court overturned the Plessy case. And in the Brown case, the country was a lot different. The civil rights movement was just beginning. The Supreme Court said, nope, separate but equal is not equal, and the Brown case overturned Plessy, thus making segregation illegal. This establishes an important power of the Supreme Court. It doesn't establish it, it just explains it. Only the Supreme Court can overturn a prior Supreme Court decision. A lower court cannot overturn a Supreme Court decision. And so this is why the Supreme Court and getting on the Supreme Court is such a big deal. The Supreme Court is the last place to decide whether a conflict or a law goes against the Constitution. Gideon and Miranda deal with due process rights. Gideon deals with getting a lawyer. And so one of the phrases that helps my students is, if you can remember, Gideon guarantees you a lawyer, that's it. That's all you need to know. If you are charged with a crime or accused of a crime, the Gideon case says a state or a local government must give you a lawyer. In Miranda versus Arizona, before the police question you, the accused person, the defendant, must know there's that word again, due process rights. You have a right to a lawyer, you have a right to remain silent, all those things you've seen in the movies. That's what the Miranda case involves. The last two cases deal with student rights. And at the beginning of this presentation, you saw a girl, Mary Beth Tinker, with a black armband. And she and a bunch of other students wore these black armbands to protest the Vietnam War. What the Supreme Court said in this very important case is that students do have limited free speech rights. Students do have constitutional rights, but these rights are limited. And you can't do whatever you want in school, but the school can't take away all of your freedoms. And it goes back to the idea that, you're supposed to get an education in school, that's true, but the school also has to look out for your safety. And if you were allowed to do whatever you want, you would probably interfere with the rights of other classmates. The last case is called the New Jersey versus TLO case. And in this case, the school was able to search a girl who was possibly had drugs on her, And because the school didn't use a warrant, the girl sued, saying the school officials had no right to search her without a warrant. Well, the Supreme Court said, well, in a school, the officials at a school do not necessarily need a warrant. All a school needs is reasonable suspicion, which is a very, very low burden of proof. You just have to have something that's reasonable to the person in order to search them. These are the 8 court cases you need to know. One of the best tools for memorizing and remembering these court cases is just to make flashcards. Put the name of the court case on one side and the decision of the court case on the other. Spend a few minutes flipping them over, memorizing them. That is the best and most helpful way to prepare for the court cases on the HSA. I hope that helps.